Today we will discuss possible defences to rely on if one is found to have infringed a trademark. If an infringement of trademark is established in Section 120 of the Commonwealth Trademarks Act 1999, defences become available under Section 122 of the Trademarks Act. This video will look at the application of the good faith defences against trademark infringement. In particular, Section 122, subsection 1, subsection A. Section 122 reads, in spite of Section 120, a person does not infringe a registered trademark when the person uses in good faith the person's name or the name of the person's place of business, or the name of a predecessor in business of the person, or the name of the predecessor's place of business. Let's say I name my plumbing business Freddy's Plumbing. Provided I did so in good faith, I will likely be able to rely on this defense. It is immaterial in this circumstance that I didn't use my full name, Frederick, as abbreviations are accepted under this section. The authority for that is Smith & Nephew Plastics Proprietary Limited and Sweetheart Holding Corp. The reference to place includes the geographical name of the city, town, or suburb in which the person's business is located, or the fiscal address of the business. In 2002, it was held by the federal court that despite a person's dominant online presence, their internet address cannot fall within the ambit of this defence. The authority for this is Buchanan Group Proprietary Limited and Saw Getty. So, what constitutes good faith? In Johnson & Johnson Australia and Sterling Pharmaceuticals, the court held that good faith requires an honest belief that no confusion will arise between their trademark and the current existing trademark, and that the mere fact that a defendant is aware of the existence of the registered trademark will not constitute a lack of good faith per se, or mere knowledge is insufficient. For the requirement of good faith to be satisfied, there cannot be an ulterior motive. A key indicator of this is to see if someone was using a specific name or place to advantage themselves. Ask, does the defendant have something to gain from using a name or place? A great example of this is in the 2002 case of Anheuser-Busch Incorporated and Budjovicki Budvar. Here, the well-known beer company Budweiser claimed trademark infringement on many of their trademarks, including the name Budweiser. The respondent, who sought to import beer under the same name, relied on the good faith defence, saying that it was the place of origin from which the beer was imported and they had an honest belief of the moral and historical entitlement to this name. The court held that because the company had researched in Australia long enough to know of the applicant's reputation and that there was at least a possibility that consumers would assume a connection between them and the applicant. Therefore, the respondent was using the name to place themselves at the advantage of being associated with Budweiser's already powerful brand, and did not adopt this name purely in good faith. So for questions regarding subsection 122(1)(a), ask yourself, is it a name or an abbreviation of a name? Is it a physical place? Was there knowledge of another trademark? And did the defendant act on this knowledge to gain an advantage? If these are satisfied, then the defendant cannot rely on the good faith defence.